Hi, my name is Elliott, and I'm a senior staff attorney with Veterans Legal Services. Today, I will be giving an overview of important issues veterans and their service providers should be aware of regarding child support in Massachusetts. This video is part of a series of presentations produced by Veterans Legal Services in collaboration with Massachusetts Continuing Legal Education. These videos are meant to assist veterans and their service providers with identifying legal issues and determining when to consult with an attorney. They are meant to be informative, but only as a general resource. Veterans in need of legal assistance should contact Veterans Legal Services by phone at 857-317-4474 to see if they qualify for free legal assistance. What is child support and how is it determined? The purpose of child support is to ensure that children have the food, clothing, and shelter that they need, regardless of the relationship between their parents. Every non-custodial parent has an obligation to pay child support commensurate with their ability to pay. In Massachusetts, child support orders are usually issued by a judge of the probate and family court. The presumptive amount of child support is set by a complicated mathematical formula as laid out in the Massachusetts Child Support Guidelines and on the Massachusetts Child Support Worksheet. This formula takes into consideration both parents' income from all sources except public benefits. The formula also considers the number of children, their ages, and the current parenting time arrangement. Then, it takes deductions from income, including for child care costs, health, dental, and vision insurance, and child support obligations either parent is paying for other children. Usually, a non-custodial parent needs to pay support until the child attains the age of 21 or becomes emancipated. However, in some circumstances, if the child is enrolled in school full-time, then a non-custodial parent may need to pay support until the child attains the age of 23 in the court's discretion. Do not stop paying child support unless a judge tells you it is okay for you to do so. If you have questions about whether your child is emancipated or whether your child support is being calculated correctly, you should contact an attorney. Next, I'll discuss what counts as income for child support purposes. There are many myths regarding what does and doesn't count as income for purposes of calculating child support. The general rule is that all money received, regardless of whether it is taxable or non-taxable, counts as income for purposes of calculating child support, except needs-based benefits. Examples of what counts as income includes service-connected disability, Social Security disability insurance, a military retirement pension, wages from compensated work therapy, a basic allowance for housing, and other GI Bill benefits. What does not count? A VA non-service connected pension, supplemental security income or SSI, supplemental security insurance or SSI, and Mass General Law Chapter 115 veterans benefits or other federal and state needs-based benefits. Next, we'll talk about what a financial statement is and why they are important. A financial statement helps the court to determine what your income is for child support purposes. If you're going to probate and family court on a child support issue, you will be asked to fill out a financial statement on pink paper. If your income is less than or equal to $75,000 a year from all sources, then you will need to fill out the short form financial statement. If it is greater than $75,000, you will need to fill out the long form financial statement. The financial statement asks for weekly numbers, so you should take your monthly numbers and divide by 4.3. For both your income and expenses. It is important that you are as accurate as possible as you are signing the financial statement under the pains and penalties of perjury. Therefore, we recommend that when in doubt, you err on the side of caution and include any income, expenses, or assets on the financial statement. We also recommend that you bring proof of your income to your court date, including your pay stubs or your benefit award letters. How do I ask the court to change the amount of support I pay? If there's been a change in your financial circumstances, such that the current amount of child support that you are ordered to pay is different than the amount that would result under the current child support guidelines, then you should file a complaint for modification in probate and family court, where your child support order originated out of. Child support arrears or past due child support is not dischargeable in bankruptcy, and there are no retroactive modifications, meaning that time is of the essence when a veteran's income changes because of a new disability or when they become disabled or are transitioning back to civilian life. It's very important that when your income changes or if you can't afford your child support payments, that you contact an attorney about filing a modification as soon as possible. When does the Department of Revenue, or DOR, get involved in your case? DOR is the agency responsible for enforcing child support in Massachusetts. If you fall behind on your child support, DOR will likely contact you, usually by mail to your last known address. DOR can levy your bank account, garnish your SSDI, garnish your retroactive lump sum SSDI or service-connected disability benefits, garnish tax returns, lottery winnings, and proceeds from some lawsuits. They can also suspend your driver's and professional licenses in order to ensure compliance with the child support order. If you receive correspondence from the Department of Revenue, it's very important that you speak with an attorney, and even if you cannot afford to pay the full amount of the order, that you pay something regularly, either on a monthly or weekly basis. DOR does not represent either party in a child support action. They have an obligation to assist both non-custodial and custodial parents. Therefore, if you cannot pay your order, you should contact them and inquire about their assistance to obtain a complaint for modification. DOR may also get involved if a custodial parent receives public assistance benefits. In that case, the court may order child support to be paid directly through the Department of Revenue. The court may also order child support to be paid directly through the Department of Revenue if there is a restraining order between the custodial and the non-custodial parents. Read your orders carefully. If they require you to pay support directly to the Department of Revenue, do not give money to the custodial parent. Otherwise, those funds that you do not pay through the Department of Revenue may not count towards your child support obligation. Where should child support fall among your other debts? Since child support is not dischargeable in bankruptcy, we recommend that you pay something towards your support every month or every week. Pay as much as you can, ideally the full amount of the order, after you pay your necessary living expenses like food and shelter. We recommend that you pay child support before paying your cell phone or cable bills because those debts may be dischargeable in bankruptcy. If you have questions, we recommend reaching out to somebody who can assist with budgeting or a credit counselor. Lastly, we'll talk about some other available resources if you're having trouble paying your support. If you're having trouble paying your support or other necessary living expenses, we recommend you consult with your Veteran Service Officer in the city or town where you live. Your Veteran Service Officer, or VSO, is responsible for administering Mass General Law, Chapter 115, Veterans Benefits, which is a public assistance benefit available for veterans. If you are receiving SSDI, or Social Security retirement benefits, your children may qualify for a dependency benefit based on your earnings record, and this money may be used to offset your child support obligation. If this is the case, we recommend you contact the Department of Revenue or an attorney for more information. If you're a veteran who's receiving service-connected disability payments, please make sure that you're getting paid at the rate of a veteran with dependents by the VA. Lastly, if you have additional questions, I recommend you consult www.masslegalhelp.org or www.mass.gov/DOR/child support. You can also contact Veterans Legal Services to see if you're eligible for free legal assistance. We can be reached by phone at 857-317-4474 or online at www.veteranslegalservices.org. Thank you.